What should have been a minor contract dispute turned into months of conflict and thousands of dollars in unnecessary expense. It didn't start with bad lawyering, it started with ChatGPT. And the problem wasn't that the software produced something obviously ridiculous. The problem was that it gave the client a convincing answer before anyone had stopped to ask whether the client was even asking the right questions. Now, before I go any further, let me just be clear. I am not anti AI. I use AI a lot. It's a remarkable tool. But there is one job that I don't want it doing. I don't want it being your lawyer. Not because it can't generate great legal sounding language, it can. The danger is that it can begin shaping your legal thinking before real legal analysis has even begun. A client came to me with what had originally been a relatively minor contract issue. It was the kind of problem that originally and probably could have been resolved with one careful conversation, a little perspective, and maybe a modest adjustment to the agreement that was in place. But before calling me, the client consulted ChatGPT. The chatbot gave the client arguments supporting the position that the client already wanted to take. It helped draft a forceful letter. The client sent it, and then the other side dug in. What had been a business discussion now became a confrontation. Trust disappeared, and months later, the relationship was destroyed. The client had spent far more dealing with the fallout than it would have cost to solve the original problem. The failure didn't begin with the answer, it began with the question. The client asked essentially, "What arguments support my position?" The software answered that question, but that wasn't the most useful question to have asked. A better question might have been, what outcome am I really trying to achieve? Or how do I solve this without destroying an important relationship? Now, consider a much simpler example. You type in draft an independent contractor agreement. Sounds like a straightforward drafting request. But before the first sentence appears, you've already made several legal judgments, whether you even realize it or not. You've assumed that the person on the other side should be treated as an independent contractor. You've assumed that classification is legally defensible. You've assumed that this is the agreement that you need. And you've assumed that the relationship should be structured this way. Those are not drafting decisions, those are legal and strategic judgments. And they should come before the document gets drafted, not after it. This is why when the client brings me an AI generated answer, I often want to see the prompts. Those prompts can be more revealing than the output. They tell me what the client was thinking, and more importantly, they reveal what the client wasn't thinking or wasn't thinking about. And the questions that were never asked are often where the most important legal issues are hiding. Every prompt frames the problem. It tells the software what to focus on and what to leave outside the picture. If you ask, how can I get out of this contract? Well, then the AI begins from the assumption that getting out is the objective. It may never challenge whether termination is wise, whether renegotiation is better, or whether preserving the relationship might be more important than winning this particular argument. An experienced lawyer steps outside that frame. We ask about the business relationship and about leverage. We ask what happens tomorrow, not only what the contract says today, we ask what a victory would cost. We ask whether the legal answer and the practical answer are the same, and frequently they're not. People sometimes assume lawyers are paid primarily to know the law. And while that is certainly a part of the job, I'll tell you, after more than 30 years in practice, I think there are much more valuable things that we bring to the table. The first is perspective, the ability to see how this immediate problem fits into the larger business, the larger relationship, and what the risk landscape looks like. Experience also produces judgment, and judgment is knowing which issues deserve attention and which ones are distractions. It's knowing when a seemingly small, innocuous clause can actually create enormous risk, and when a frightening looking provision is unlikely to matter. Software can identify possibilities, but judgment helps determine which possibilities should drive the decision. And then there's strategy. Strategy isn't simply knowing what you're legally entitled to do. It's deciding what you should do to produce the best real world outcome. Sometimes the strongest legal argument isn't the smartest opening move. Sometimes sending the most aggressive letter available creates exactly the response you were hoping to avoid. And then there's wisdom. Wisdom is the residue of having seen hundreds or thousands of deals and disputes and decisions unfold. It's recognizing patterns. It's remembering that case that looked harmless until one missing sentence caused a disaster. It's knowing that the obvious answer isn't always the useful one. A client once brought me a contract that looked completely professional. It was well formatted, the language sounded formal and legalistic, the provisions looked familiar. It looked exactly like the kind of contract most people would sign without a second thought. But on careful review, it revealed that there was a crucial clause missing. Another provision allocated a major risk precisely in the wrong direction. If the client had relied on that agreement, the consequences could have been catastrophic. The document looked polished. It was not protective, though. Looking like a lawyer and thinking like a lawyer are just not the same thing, and that goes true for legal documents as well. This is also why bringing an AI-generated contract to a lawyer and asking us to just check it isn't necessarily the most efficient approach. By that point, the software has already selected the structure, defined the relationship, prioritized certain risks, and ignored others. That first draft becomes an anchor. And instead of designing the right solution, everyone begins editing the solution that the machine proposed. Real lawyering often begins before there's a document. It begins with facts, objectives, concerns, relationships, and possible outcomes. Sometimes the right answer is actually a different contract altogether. Sometimes it's a different deal structure. Sometimes the best advice isn't to enter the deal at all. The value isn't merely in improving the words, it is in determining what should exist there in the first place. Your first legal consultation should be with your lawyer, not with software. Bring us the problem before you bring us the conclusion. Tell us what happened. Tell us what you want. Tell us what you're worried about. Let us help identify the real problem before anyone begins drafting a supposed solution. One reason AI can feel so persuasive is that it often works within the assumptions we give it. It can reinforce our instincts. It can generate arguments that support the position we already favor. It can tell us in polished, confident language exactly what we were hoping to hear. An experienced lawyer may do something much less comfortable. We may challenge the premise. We may tell you that your strongest argument isn't as strong as you think. We may explain that you are legally right, but strategically unwise. We may tell you that the outcome you want is unlikely, or that pursuing it will cost more than it's worth. That may not be what you wanted to hear, but it may be exactly what you needed to hear. When you hire an experienced lawyer, what are you really buying? You're not simply purchasing access to statutes and cases or familiar contract language. Most of that information is widely available. You are hiring someone to apply experience and wisdom to your specific facts, goals, risks, and relationships. The document is just the visible output. So it's easy to assume the document is the product. But often, the most valuable work happened before the document was even written. It happened with the questions, the analysis, the reframing, the identification of alternatives, and the decisions about which risks to accept. These are the things experience brings to the table. Judgment about what matters, perspective about what pieces and how the pieces fit together, strategy about how to move forward and toward the best result, wisdom about what can happen next. AI can support some parts of legal work, but it shouldn't be mistaken for the source of these qualities. So here's my advice. Don't rely on AI as your legal advisor. Bring your lawyer your facts, your goals, your concerns, and your questions. Let your lawyer help determine what problem you're actually trying to solve. And then use the available tools appropriately, because value isn't in the document. The value is in the thinking that produces the document.